All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated, veuillez vous asseoir.
Morning. First of all, excuse me for my sunken voice. The court officer, would you like to call the case, please?
Thank you, Mr. President. The situation in Darfur, Sudan, in the case of the prosecutor versus Abdallah Banda, Abaker, Nourain, ICC 0205-0309. We are in open session.
Thank you. My name is Judge Sang-Hyun Song, and I am the presiding judge on this appeal arising from the case of the prosecutor versus Abdallah Banda, Abaker, Nourain. May I ask the parties to introduce themselves for the record, starting with the defense.
Good morning, Mr. President. From Mr. Banda today are Anand Shah, Joshua Bichet, and myself, Lee Laurie.
Thank you. The Office of the Prosecutor.
Good morning, Mr. President. Helen Brady, Senior Appeals Counsel, and I'm here today with Mr. Julian Nichols, Senior Trial Lawyer, and Mr. Reinhold Galmatster, Appeals Counsel. Thank you.
Thank you very much. And victims' representatives.
Merci, Monsieur le Président. Les conseils étant empêchés, l'équipe des représentants légaux des victimes sera représentée exceptionnellement aujourd'hui par Monsieur Dao Sali, qui est notre assistant du terrain, et par moi-même, Mademoiselle Evelyne Ombeni, chargée des dossiers. Merci.
Merci. Thank you very much. Today, the appeals chamber is delivering its judgment on Mr. Banda's appeal against the decision of Trial Chamber 4, entitled Warrant of Arrest for Abdallah Banda, Abaker, Nourain. That decision was rendered on the 11th of September 2014. In today's summary, I will refer to this decision as the impugned decision. I shall now summarize the appeal chamber's judgment and the reasons for it. This summary is not part of the written judgment, which is the only authoritative account of the appeals chamber's ruling and reasons. The written judgment, which is unanimous, will be made available to the parties at the conclusion of this hearing. I shall start with the brief procedural history. On the 27th of August 2009, Pretrial Chamber 1 issued a summons to appear for Mr. Banda, without prejudice to a review of this decision at the later stage. The trial date initially set for the 5th of May 2014 was vacated by the trial chamber on the 16th of April 2014. The trial chamber later decided that the trial should commence on the 18th November 2014. After receiving various submissions from the parties and participants on the question of Mr. Banda's appearance for trial, the trial chamber issued by majority, Judge Eboe Osuji dissenting, the impugned decision. In the impugned decision, the trial chamber concluded, on the basis of its review in accordance with Article 58, paragraph 1b(1) of the Rome Statute, that a warrant of arrest appeared necessary to ensure Mr. Banda's presence at trial. Further to an application from Mr. Banda, the trial chamber by majority, Judge Eboe Osuji dissenting in part, granted leave to appeal one issue arising from the impugned decision. The issue is whether the trial chamber erred in not hearing further from the defense on the appropriateness of replacing the summons to appear by a warrant of arrest after being satisfied that the accused would not appear voluntarily for his trial. On appeal, Mr. Banda argues that the trial chamber erred when it issued the impugned decision without providing him with an opportunity to be further heard on the legal and factual basis, as well as on the propriety of replacing the summons to appear with a warrant of arrest. In Banda's view, the trial chamber was required, in accordance with the audi alteram partem principle, to invite and consider submissions from him before replacing the summons to appear with the warrant of arrest. The appeals chamber notes that Mr. Banda, while generally alleging that the issue on appeal is a procedural one, does not demonstrate that in the absence of the alleged error, the decision would have substantially differed from the one rendered, as is required under the appeals chamber's jurisprudence. Despite this deficiency, the appeals chamber has addressed the alleged procedural error, namely whether the trial chamber was required to hear further from Mr. Banda before issuing the warrant of arrest. The appeals chamber considers that in the circumstances of the present case, this question falls within the trial chamber's discretion as to the conduct of the proceedings under Article 64 of the statute. In this respect, this appeals chamber recalls that it will not interfere with the trial chamber's exercise of discretion, save one, where the exercise of discretion is based on erroneous interpretation of the law. Two, where it is exercised on patently incorrect conclusion of fact. Or three, where the decision is so unfair and unreasonable as to constitute an abuse of discretion. The appeals chamber finds that Mr. Banda has not established that the trial chamber's exercise of discretion in the case at hand was erroneous. For the reasons given in the written judgment, the appeals chamber finds that the trial chamber's decision was not based on an erroneous interpretation of the law, and that the trial chamber's discretion was not exercised on the basis of a patently incorrect conclusion of facts, or that its decision was so unfair and unreasonable that it constituted an abuse of discretion. In this context, the appeals chamber notes that Mr. Banda has not identified any relevant facts that were either ignored or erroneously relied upon. As Mr. Banda has not identified any error on the part of the trial chamber, it is not necessary for the appeals chamber to consider whether any such error materially affected the impugned decision. In the above circumstances, the appeals chamber deems it appropriate to confirm the impugned decision. The appeal of Mr. Banda is therefore rejected. This concludes my summary of the judgment, and my last task is to thank the interpreters, court reporters, and court officers. The session is now closed.
All rise, vous vous levez.